Here's my plan to tackle that topic. Let me know if you need to make changes. I've completed your research. Feel free to ask me follow-up questions or request changes.
The attorney prioritizes his standing in that professional network over his client's case. But while that's an appearance issue, the report moves to next.
You know that sinking feeling when you realize a game is just completely rigged?
Oh yeah, that is definitely not a good feeling.
Not at all. Well, imagine walking into a court in Indiana for a custody battle. You're expecting a fair fight, right?
Yeah.
You have your counsel, the other side has theirs, and then there's the guardian ad litem.
The referee, essentially.
Yeah.
The court-appointed neutral looking out for the child.
Exactly. You assume everyone stays in their own distinct lanes. But today's deep dive into a really specific forensic analysis of an Indiana family law case suggests those lanes aren't just merging, they are basically the same parking lot.
It's a fascinating report. We are looking at an investigation into systemic ethical conflicts. And we aren't just gossiping about lawyers here.
Right, right.
We're unpacking how professional networking can actually cross the line into ethical violations. It completely compromises due process and that core standard, the best interests of the child.
So let's lay out the players. Under Indiana law, attorneys like Michael Commons owe what's called zealous advocacy to their client. But neutrals, like the GAL Marsha Hackenberg or the mediator Robert Shrive, they have to maintain absolute independence.
Right, and that brings us to what the source calls Nexus 1. This is the club problem. The investigation verified a link between the adverse counsel Commons and the GAL Hackenberg. They're both active members of the AFCC.
Which is the Association of Family and Conciliatory Courts. Now, to anyone listening, that probably just sounds like a benign professional group.
It does. But the report points out that GAL Code of Ethics Rule 6 demands the appearance of fairness. The AFCC promotes a highly collaborative ideology. So the argument here is that belonging to this collaborative organization with opposing counsel...
It creates an appearance of impropriety.
Precisely. It forces the lawyer to pull their punches.
Because you can't aggressively cross-examine the GAL on the stand if you're worried about saving face at your next networking event. It just neuters that zealous advocacy Commons owes his client.
Yes. The attorney prioritizes his standing in that professional network over his client's case. But while that's an appearance issue, the report moves to Nexus 2, which is much more tangible. This is the playbook problem.
Oh yeah, this part is wild. We're moving from just bad optics to potential hardline disqualification. The report links the GAL's attorney, Leah Burris, to the litigant's former counsel, Alexandria or Amelia Miller.
This is a massive distinction. Under Rules of Professional Conduct 1.9 and 1.10, which deal with conflicts of interest, we have an actual conflict. The report indicates these two lawyers worked at the same firm previously.
Which means, practically speaking, Burris might effectively have the litigant's entire playbook through imputation.
Exactly. The law assumes information known by one lawyer in a firm is known by all. So Burris has the confidential info, the vulnerabilities.
And since she represents the GAL evaluating that very same litigant, it's a completely unfair advantage. It's an actual conflict. The referee literally has your game plan.
And usually that warrants mandatory disqualification.
But the web doesn't stop there. We have to touch on Nexus 3, the mediator, Robert Shrive.
Right. Under Indiana ADR rules, a mediator has an absolute duty to disclose any connections to the parties or their attorneys. But the report alleges Shrive failed to disclose his connections to the GAL's attorney.
Because if the mediator is buddies with the GAL's legal team, the pressure to settle isn't applied equally. A mediator with those undisclosed ties might subtly steer the parents toward a resolution that just protects the GAL rather than helping the family.
It creates a completely coercive environment. The report concludes this isn't just bad luck, it describes it as an interconnected professional ecology.
A systemic compromise. The adversarial system just completely fails because everyone's too close. The lawyer is supposed to check the GAL, the mediator checks the conflict, but here, professional harmony is prioritized over the client's rights.
It is. The fundamental fairness of the court is eroded. The court ceases to be a finder of fact and just becomes a rubber stamp for whatever this professional club decides.
It really highlights this huge tension between professional collaboration and zealous representation. So we want to leave you with a provocative thought. If the people paid to fight for you and the people paid to be neutral are all attending the same conferences and mixers, at what point does cooperation become actual collusion? Definitely something to think about the next time you hear the word unbiased. Thanks for joining us on this deep dive.
This Indiana Lawyer audio file is brought to you by Dentons. As an Indiana Lawyer subscriber, you can listen to articles at work, in the car, or while you work out. Subscribe now.
Welcome to today's deep dive. We are unpacking a phrase that honestly sounds like a spell from a fantasy novel, but is actually a real nightmare in family law. Ultravires. It translates to acting beyond powers.
Yeah, and in the context of our source material today, it is definitely not abstract. We're looking at a specific legal report regarding an Indiana parenting coordinator, Robin Brown Niehaus. The core allegation here is that she took the authority granted to her by a court and basically stretched it until it broke.
Right, and let's clarify what a parenting coordinator, or PC, actually is first. Reading through the Indiana Parenting Time guidelines, they sound like referees for high conflict divorces, people who step in when parents just cannot agree on a schedule.
They are referees, but with a very specific leash. I mean, their authority is strictly derivative. It does not come from them. It flows directly from the judge's order. They are appointed to help you follow the rules, not to write new ones.
Which brings us to the specific incident in the report. It alleges Niehaus unilaterally removed a step called discussion and mediation from the dispute resolution process. But let me play devil's advocate for a second. If these parents are already in high conflict, isn't cutting out the discussion part just efficiency? Why is that such a massive constitutional issue?
Because efficiency cannot trump due process. The report argues that by removing discussion and mediation, the PC stripped the parents of self-determination. In family law, you have a fundamental right to try to resolve disputes yourself first.
So it is like a referee at a football game just canceling halftime. You cannot just change the structure of the game because you want it to move faster.
Exactly. The PC shifted the dynamic from collaborative, where parents have a voice, to authoritative, where she simply dictates. The source calls this a jurisdictional encroachment. A PC can clarify logistics, like changing a pickup from 5 to 5:15, but they cannot materially alter how disputes are actually resolved.
That is a crucial distinction. Logistics versus process. Now, the report suggests this overreach is even more concerning because of the history involved. The source digs into public records from 1988 in the matter of Robin L. Brown.
And this is not just a bad review. This was an Indiana Supreme Court finding that resulted in a 1-year suspension of her law license. The language the court used was incredibly sharp. They found conduct involving dishonesty, fraud, deceit, or misrepresentation.
Wow, that is a heavy label for anyone in the legal system. But why is a case from nearly 40 years ago relevant to a parenting coordinator today?
Because of immunity. PCs enjoy quasi-judicial immunity. You basically cannot sue them for bad decisions because they are supposed to be neutral extensions of the court. That shield is predicated on the assumption of absolute integrity.
So the argument is that the shield should not apply here.
Right. The report argues that you have a demonstrated bias. You have a historic finding of fraud combined with a current allegation of breaking court rules to impose authority.
It suggests the system is protecting someone who might be unprotectable. So for you listening and looking at this data, what is the actual recourse? The report lists some specific motions, right?
Yes, 2 distinct moves. First, a motion to terminate the appointment, which argues the PC exceeded their mandate. Second, a motion to set aside. This asks the judge to throw out any orders the PC made after she removed the mediation step.
Because if she broke the rules to make those decisions, the decisions themselves should not stand.
It is about resetting the playing field. And it leaves us with a difficult question. The parenting coordinator is hired to be the neutral solution to a conflict.
But if the solution goes rogue?
Exactly. If the person hired to manage the conflict ignores the boundaries of the court, do they become a bigger liability than the fighting parents ever were?
That is the thought for you to chew on today. Thanks for joining this deep dive.
The specific allegation that the parenting coordinator, PC, Robin Brown Niehaus, interfered with school dismissal and unilaterally allowed pickups by the father, despite the mother holding sole legal and physical custody and being a domestic violence victim, introduces critical and actionable grounds for professional misconduct and a denial of due process. This action, if proven, represents a profound and direct violation of the PC's mandate and the foundational principles of Indiana family law, which prohibit the PC from materially altering court-ordered custody arrangements. Legal analysis of ultra vires modification of custody. The parenting coordinator's authority is strictly defined as derivative of the court order, and the PC is expressly forbidden from assuming judicial authority or modifying substantive court orders. 1. Usurpation of sole legal custody authority. When a party holds sole legal custody in Indiana, that parent has the exclusive authority to make major decisions concerning the child's education, health, and welfare, which includes who is authorized for pickup from school or activities. The PC's role is limited to clarifying misunderstandings about parenting time exchanges or proposing solutions for logistical issues. A unilateral decision by the PC to interfere with the school's dismissal process and grant the non-custodial father authorization for pickup against the explicit direction of the sole legal custodian is not a logistical clarification. Instead, it constitutes a material alteration of the physical custody arrangement and an override of the mother's legal decision-making authority. The PC is explicitly prohibited from materially altering court-ordered parenting plans or substantially altering the percentage of parenting time. The court retains exclusive jurisdiction to determine these issues. By issuing an instruction that usurps the sole legal custodian's control over the child's immediate physical location and dismissal process, the PC acted ultra vires, beyond her delegated authority, and attempted to exercise the judicial power of custody modification, which she does not possess. 2. Violation in the context of domestic violence. The fact that the mother is a documented victim of domestic violence significantly escalates the severity of the alleged misconduct. Indiana law recognizes that the appointment of a PC may be contraindicated where domestic abuse or domestic violence is alleged, suspected, or present. If the PC was appointed despite the presence of domestic violence, she was operating under a heightened duty to ensure the safety and procedural protections of the victim and the child. Unilaterally changing the custody logistics, school pickup, to increase physical access or control by the alleged perpetrator, the father, without the victim's consent, demonstrates a failure to act consistently with the Indiana Parenting Time Guidelines. This action may be viewed as demonstrating bias or acting in a manner inconsistent with the guidelines, as it prioritizes the non-custodial parent's access over the sole custodial parent's safety and legal authority. 2. Actionable grounds for termination of appointment. The specific interference with school dismissal and custody logistics provides two strong, distinct legal grounds for immediate action under the Indiana Parenting Time Guidelines. 1. Exceeding mandate, ultra vires. The PC is subject to termination if she has been found to have exceeded her mandate. The unilateral override of the sole legal custodian's authority over school pickup and child safety protocols is a clear, objective example of the PC making a substantive decision that impinges on custody, a matter reserved exclusively for the court. This action provides sufficient grounds to petition the court for the immediate termination of the PC's appointment. 2. Demonstrated bias and fitness. By actively intervening to facilitate access for the father, the non-custodial parent, in direct contravention of the sole custodial parent's decision, especially given the domestic violence context, the PC's actions create a substantial argument of demonstrated bias. Furthermore, the PC's historical professional discipline, which involved findings of dishonesty, fraud, deceit, or misrepresentation, compounds the current allegation. This history supports the argument that the PC lacks the requisite integrity and impartiality to fulfill the role, creating other good cause for termination. The correct strategic approach is to file an expedited motion to terminate the parenting coordinator appointment, detailing both the ultra vires act of modifying the custody order and the demonstrated bias, using the domestic violence context and the PC's professional history as aggravating factors supporting the request. The additional allegations regarding the parenting coordinator, PC, Robin Brown Niehaus, specifically involving school resource officers harassing the mother with police intervention during medical appointments and acting against the mother as sole legal custodian and domestic violence victim, represent severe claims of professional overreach and abuse of process. These actions, if documented, move beyond simple jurisdictional error into coercive and potentially abusive conduct, providing substantial new grounds to petition the court for the immediate termination of the PC appointment and for sanctions. Legal analysis of coercive conduct and abuse of process. A parenting coordinator's role is defined as a conflict management and dispute resolution process, intended to be facilitative and educational, not coercive or punitive. The PC is explicitly prohibited from attempting to exercise judicial authority, utilizing law enforcement or school resource officers, SROs, to enforce a preference or instruction that materially alters the existing custody order, especially by overriding the sole legal custodian's decision, constitutes a 1. Unauthorized use of law enforcement. APC does not possess the authority to summon or direct law enforcement intervention to enforce their administrative recommendations. The PC's power to make binding recommendations, if granted by the court at level 2 or 3, is subject to immediate judicial review upon objection. Utilizing police action to interrupt a medical appointment or a school procedure based on a unilateral, unreviewed instruction is a severe violation of procedural rights. Such actions suggest the PC is attempting to enforce a binding legal mandate unauthorized by the court, effectively acting as a private judge with police enforcement powers. This behavior is inconsistent with the non-adversarial spirit of alternative dispute resolution, ADR, and directly infringes upon the court's exclusive jurisdiction to determine issues of custody and parenting time. 2. Interference with sole legal custody and medical care. As the sole legal custodian, the mother has the exclusive legal right to make major decisions concerning the child's welfare, including choices regarding medical care and safety protocols. Harassment by police during a medical appointment, allegedly initiated by the PC, interferes with the mother's ability to fulfill her legal duties as the custodial parent and compromises the confidentiality and efficacy of the child's medical treatment. The PC's mandate is to assist with choosing service providers and logistics, REC, not to actively intervene in the middle of a private medical appointment by using law enforcement to intimidate or coerce the sole custodian. This conduct, especially when compounded by the previous unilateral attempt to change school dismissal, demonstrates a pattern of exceeding the mandate and demonstrated bias against the sole legal custodian. 3. Ignoring domestic violence context. The Indiana Parenting Time Guidelines acknowledge that the appointment of a PC may be contraindicated where domestic abuse or violence is suspected or present. When a PC employs law enforcement as a tool of coercion or harassment against a domestic violence victim, it mirrors the very dynamics of control and intimidation that the court process is intended to protect against. This demonstrates a failure to adhere to the guidelines and provides further evidence of a demonstrated bias that compromises the PC's neutrality. 2. Legal grounds for termination and judicial review. The actions alleged, utilizing police and interfering with medical appointments and school logistics, provide multiple compelling grounds for judicial intervention. Legal ground. Indiana authority. Rationale based on alleged conduct. Exceeding mandate. Ultra vires. PC Guidelines, Section VA 4. The PC attempted to modify custody/parenting time logistics through law enforcement, an action exclusively reserved for the court, acting inconsistently with guideline. PC Guidelines Section VA 5, VC 11. Coercing a domestic violence victim and overriding the sole legal custodian's authority is inconsistent with the child-focused, protective principles of the guidelines. Demonstrated bias, PC Guidelines Section VC 11. The pattern of unilateral actions favoring the non-custodial father and the use of coercive police tactics against the mother strongly demonstrates a lack of impartiality. Other good cause? PC Guidelines Section VC 11. The combination of a historical professional finding of dishonesty and the current pattern of abusive and unauthorized use of law enforcement severely undermines the PC's fitness and integrity to serve. 3. Strategic recommendation. The severity of the alleged actions mandates immediate and comprehensive legal action. 1. Motion to terminate appointment. Counsel should immediately file a motion to terminate the parenting coordinator appointment, detailing the PC's pattern of ultra-vires actions. 1. Removing court-ordered procedural steps, discussion/mediation. 2. Unilaterally changing school dismissal procedures against the sole legal custodian's directive. And 3. Abusing authority by involving police/SROs to enforce unauthorized demands and harass the mother during. These points establish that the PC has exceeded her mandate, demonstrated bias, and provided other good cause for removal. 2. Preservation of evidence. All communications with the school resource officer, SRO, police reports, and medical records related to the alleged harassment must be meticulously documented and attached as exhibits to the motion, as evidence is crucial for supporting claims of bias and professional misconduct. 3. Request for hearing. A request for an expedited hearing should be made, emphasizing that the PC's actions pose an immediate threat to the child's stability and the mother's safety as a domestic violence victim. The termination of the parenting coordinator, PC, appointment confirms the validity of the claims regarding her profound overreach. Your concern is now shifted appropriately to the lasting impact of this period, as the PC's actions, especially the ultra-vires alteration of custody logistics and the use of coercive tactics, likely created a legally and emotionally compromised environment. The fact that the PC was removed validates the argument that she exceeded her mandate or demonstrated bias. The legal strategy must now focus on securing judicial remedies for the damage done, challenging the legitimacy of any orders or the status quo resulting from her unauthorized conduct. Legal characterization of the damage done, the PC's alleged actions, unilaterally changing school dismissal, allowing unauthorized pickups, and using police/SROs to interfere with medical appointments are categorized as severe violations of professional and judicial authority. Alleged action by PC. Legal violation. Rationale. Interference with sole custodian's authority. Ultra-vires act/abuse of mandate. As sole legal custodian, the mother possessed the exclusive right to make decisions regarding medical care and school dismissal. The PC is expressly prohibited from modifying legal custody or materially altering the parenting plan. The PC's actions functionally modified the custody order, an act reserved exclusively for the court. Coercion and harassment. Demonstrated bias/abuse of process. Utilizing law enforcement to interrupt a private medical appointment is a coercive tactic that is fundamentally inconsistent with the PC's role as a facilitative neutral. This conduct, particularly against a domestic violence victim, provides clear evidence of demonstrated bias and a failure to act in the child's best interest, which warrants termination. Compounding factors: fitness, professional integrity, and trust. The PC's historical disciplinary record for misconduct involving dishonesty, fraud, deceit, or misrepresentation is highly relevant. It provides compelling evidence of a lack of professional integrity, underscoring why the PC should never have been entrusted with quasi-judicial authority over a domestic violence victim or a sole legal custodian. 2. Post-termination judicial remedies. Since the PC has already been terminated, the focus must shift to vacating or mitigating the effect of her unauthorized actions and stabilizing the child's environment. 1. Motion to set aside or vacate tainted decisions. If the PC's unauthorized actions, e.g., changes to pickup times or medical protocols enforced by police, were formalized by a court order, or if her coercive presence led to an adverse mediated agreement, a motion for relief from that specific order is the appropriate remedy. Legal basis. A court decision may be challenged if it was based on an abuse of judicial discretion or if constitutional or procedural rights were violated. Argument. Counsel should argue that the specific order or agreement, e.g., a specific parenting time schedule, was tainted because it was either the direct result of the PC's ultra vires recommendation, modifying custody or procedure, which she had no legal capacity to make, the product of coercion, bias, and a denial of due process due to the PC's unauthorized use of police power and interference with the sole custodian's rights. 2. Petition to modify custody or parenting time. The systemic damage caused by the PC's overreach, the breakdown of the child's stable environment, the harassment, and the compromise of safety protocols in a domestic violence case constitutes a substantial and continuing change in circumstances. Argument. The misconduct of the parenting coordinator, which included overriding the safety and authority of the sole legal custodian, is evidence that the current custody arrangement is no longer in the child's best interest, particularly if the court-ordered access created an unsafe or highly conflictual environment. This provides a clear legal basis to petition the court to modify the existing custody or parenting time arrangement to restore stability and fully protect the child and mother from further conflict or abuse of process. 3. Professional accountability. While termination addresses the immediate threat to the parties, the court retains a supervisory duty over its appointed agents. Request for judicial findings. Counsel should urge the court to issue specific written findings that detail why the PC was terminated, i.e., exceeded her mandate, demonstrated bias. Such findings are critical as they solidify the grounds for any future appeal or challenge to orders that were issued during the PC's tenure. Reporting misconduct. Since the PC is a registered domestic relations mediator and attorney, her conduct may warrant reporting to the Indiana Supreme Court Disciplinary Commission. The pattern of ultra vires acts, abuse of process, and demonstrable bias, coupled with the PC's documented professional history of dishonesty, suggests a lack of fitness to serve as a neutral officer of the court. Here's my plan to tackle that topic. Let me know if you need to make changes.